Senator Back.
Thank you, Acting Deputy President. We all know in this place that those of us in parliament are quite rightly the subject of full accountability and transparency. My contribution today unfortunately reflects the fact that I don't think the same standards are applying in Australia's judiciary, and I'm very concerned about this and I want to draw it to the attention of the chamber. I will conclude my comments in a relationship of the Nagel case in the High Court of Australia between the Rottnest Island Authority and Nagel in the 1990s. But I want to lead off this discussion with the regrettable incidents that led to the Lindt Cafe siege on the 15th of December 2014. The gentleman Man Monis had been the subject in the courts, in the New South Wales court in 2009, because he had been writing letters to the families of deceased soldiers and others. 2011, Court of Criminal Appeal in Sydney. 2014, he goes to the High Court of Australia on a postal service-related matter. But in May of 2014, the man is granted bail by Magistrate Joan Baptiste in New South Wales, despite her acknowledging that he may endanger the safety of victims, individuals and the community, he may interfere with witnesses or evidence. And yet she granted the man bail because, to quote, she thought there were significant flaws in the Crown's case. In October 2014, this man is again charged, this time with 40 sexual assault charges against 6 women. He applies for bail. Magistrate Darrell Pinch gives him bail. He was due, of course, then back in court on the 12th of December, deferred to February 2015. In the meantime, he causes the Lindt Cafe siege with the death of 2 innocent people. I go to the 2nd of November 2016 in Queensland. Magistrate Trevor Morgan in the Pine Rivers Judiciary. 3 young women were apprehended on the roof of the Minister for Immigration's office, Peter Dutton. This is his comment to them in finding them guilty. If one of my daughters was caught doing like you did, I'd probably be very proud of her. He fines them $100, despite more than $10,000 of legal and police costs. So what happens on the 29th of November, 2 weeks later, in the same state? At least one, if not more, of those young women are down here in Parliament House vandalising furniture and disrupting question time in the other place. I go to the Gargasoulis incident in Burke Street in Melbourne only on the 20th of January. Again, not an incident I want to speak about in great detail, Acting Deputy President, but what did we find there? This gentleman, long history of domestic violence, had been granted bail over and above the pleas and objections of the police. He was due to appear in court on that same day, the 20th of January, but what did he do? As we all saw, so I'll say it, allegedly created a heinous crime in which to date 6 people have been killed. I then go, only the other day when I was in Queensland for a Senate hearing, do I hear about the tragic death of Teresa Bradford on the 31st of January, only a week ago. November of 2016, her estranged husband is placed into custody because of what would be alleged to be an horrific attack on this woman, and yet in the middle of January, the gentleman is granted bail again over the urgent pleas of the police. She is not warned of the fact that he's been let out on bail, and on the 31st of January she's murdered, he's suicided in front of their 4 children. I ask the question, Acting Deputy President, what is bail all about? The Act instructs the courts to start with the presumption that an accused person should be granted bail unless there's a justified reason to refuse it. And what might they be? The nature and the seriousness of the crime, the character of the defendant, past criminal record, association, ties with the community, the defendant's record in regard to previous commitments to bail, the strength of the evidence. Where's the word relating to the victim in all of this and in the cases that I have referred to? Acting Deputy President, Nagel was a most interesting case, and it led to the rewriting of public liability practice in this country. In 1977, the gentleman was an employee at the Rottnest Island in Western Australia. As you, Senator Sterle, would know as well as I do, there's a place called the Basin. Tens of millions of people have swum at the Basin, probably the safest spot to swim. The man goes to the Basin on a Saturday morning. Instead of going straight into the water, he walks 50 metres over sharp rocks and dives into the water and comes out a quadriplegic. Absolutely tragic. I'm not suggesting the Australian community shouldn't support him. I was the Chief Executive at Rottnest Island when he brought an action against the Island Authority on the public liability basis that there should have been a sign to say there were rocks. You know, as I know, the island is a rock, as Senator Cash herself well knows. We won the case in the Supreme Court in '89. There was an appeal to the Appeals Court in Perth. We won that in '91. And yet it went to the High Court of Australia in 1993 and it was lost. I begged and pleaded to be allowed to be a witness before the High Court of Australia as the Chief Executive of the Island Authority and was not allowed to do so. So, of course, we went from being 0% culpable to 100% culpable in that case, cost the Island Authority millions of dollars in legal costs and indeed in the public liability space, and it rewrote. It changed completely. It is the reason why playgrounds were pulled out of schools and local governments around Australia, because on the basis of Nagel, public liability payments were made. The then Governor of the state had been the Chief Justice of the Supreme Court, Sir Francis Burt, a person known to Senator Cash and her family, and he said to me, Chris, he said, I'll tell you two things. One, it will be seen as the worst judgment in the history of the High Court, and he said, secondly, it won't help you, but over time they will pull out the planks in the platform. I was talking on one occasion to retired High Court Judge Sir Ronald Wilson as we walked along the Canning River in Mount Pleasant, and I said to him, Sir Ronald, if you were still on the High Court of Australia, we wouldn't have lost the case. And he said, Chris, why would you say that? I said, because the information available to me, Sir Ronald, is that the justices of the High Court took the Basin at Rottnest to be akin to the Gap in Sydney, and in their mind's eyes you would obviously expect signs at the Gap in Sydney. He said to me, that can't be right. I happened to be walking with him again some weeks later, and he drew my attention to that conversation. He said, I've actually made some inquiries, Chris, and do you know you were right? He said, I'm not saying the judgment swung on that, but in the mind's eyes of those justices from the eastern states of Australia, they thought the Basin was like the Gap in Sydney. And so we had a circumstance then in which we went from being 0% culpable not only to 100% culpable, but the High Court got it wrong. But there's no right of appeal to the High Court of Australia, and as I say, we weren't allowed to appear as a witness. We weren't allowed to present evidence. The very first movie ever made in the state of Western Australia was that of people swimming at the Basin. The concept of putting a sign on a limestone rock called the island that there might be rocks here is a nonsense. The sign, for example, might not be illuminated at night. It might not be able to be read by people who can't read English. It might be too high for children or too low for others. Acting Deputy President, it did interest me, incidentally, only the other day when the matter of our last or past colleague, then Senator Bob Day, was dealt with the High Court of Australia. Witnesses were permitted. Then Senator Anne McEwen, or past Senator Anne McEwen, had a representation of witnesses to the High Court of Australia. Our QC at the time was Michael Murray QC, who went on to become, if I'm not wrong, through you to Senator Cash, a Supreme Court judge himself. And Michael Murray said to me in preparing for the case, he said, tell me why you can't comprehend that this man has either made a mistake or that he should have known he was amongst rocks. And I said to him, Michael, if I was walking across Subiaco football oval, I might reasonably expect to be hit on the head by a football, but I wouldn't expect to be hit by a train. And yet, as I said to him, if I've walked over sharp rocks, and I have done it incidentally, if I walked over sharp rocks barefooted for 50 metres It must surely be in my mind's eye that I'm amongst rocks. Acting Deputy President, the judiciary needs to be far more transparent and far more accountable.